we are going to cover a lot of stuff today, or they are. I'm just here to be boring for a moment. So a whole bunch of announcements. First, our next webinar, which is on December 10th. So the December 10th webinar will cover the Medicare fee schedule, which came out in review copy on Trick or Treat on Halloween, and the final version will come out tomorrow morning. Gotta say, I've read a lot of it. It's one of the dullest fee schedules I've ever seen, but we'll talk about what's in there next week or next month. We'll also talk about the hospital outpatient rule and also the OIG work plan. If you can't go a whole month without us, on December 3rd, one of our colleagues, Karen Shanfield, is going to have a webinar talk with Krista Hatcher, one of our other colleagues, about how to address the incidence of communicable diseases in the workplace. So if you're wondering, what do we do with Ebola and other stuff like that, you can check out that webinar. That's at noon Eastern, or sorry, 1 Eastern, 10 Pacific on December 3rd. This webinar and all of our health law webinars appear on SlideShare, so you can always look those up. The link will come out when you get the handouts. There will be a link to the SlideShare materials in there. You can ask a question at any time by clicking on the chat box. If for any reason your chat box has disappeared, there should be at the upper right corner a little window that says chat. Click there to type your questions. That's also where you'll get information from our crack producers. If you notice the sound breaking up because of slowness in the internet, that often happens over noon, we can't control that, but we can solve it. Use the dial-in number that's in the chat box. Okay, one last announcement. We have a boatload of clients right now who are finding themselves wanting temporary legal help. And what's worked really well for some of them is we have a crack team of associates. And some of our clients are borrowing from those associates from us. Some have the people come on site, but many don't. We're really lucky. We've got a bunch of ridiculously smart, practical, and fast associates. Pari McGraw just started last month, and so she joins the team. So that's an option. If you need anyone, feel free to let one of us know. And what you basically do is you call them directly, and they're yours. Okay, now, on to today. So last January, we were lucky enough to have John Kapacinskas join us. John came from Fulbright and Jaworski, and before he started their Minneapolis office, he practiced in Texas. So John's a healthcare litigator. He works on a wide range of disputes, but he's developed particular expertise in bid protest work. He's done that in more than a dozen states. He's also done a bunch of disputes between health plans and hospitals and clinics. I know there's been one that's been keeping him busy lately. And finally, he does a lot of work on today's topic, medical malpractice. So John is part of what's, I guess, our burgeoning medical malpractice group that includes Greg Karpenko, Dave Bundy, and his fellow presenter, Erin Secord. So Erin's in our litigation group, and in addition to doing MedMail, works on a wide range of other sort of litigation-type stuff in healthcare and in other areas. So with that long wind-up, I'm going to turn it over to John. Take it away, Mr. Kapacinskas.
Thank you very much, David. Thank you, everybody, for joining Erin and me today to talk about medical malpractice cases. And what we thought we would do would be to have a practical discussion about working with outside counsel. I know many of you, this is not your primary concern, handling medical malpractice cases, and it's one among many issues that come up in your day-to-day activities. And so we wanted to keep this very practical. Honk if you love litigation. I say that with extreme sarcasm because everybody here I know does not enjoy litigation. It's expensive, it's time consuming, it takes your folks away from their business activities. The disruption to your work is phenomenal. And many of you wear lots of hats, and this is the last thing on your list to do. So what we wanted to do would be to talk about issues that arise, that your input is very helpful, helps drive the value of a case down. It helps us represent you most effectively. And so those were the things that we thought we would discuss with you today.
And we'd like to give you a brief overview of the 5 topics that we're going to be covering over the noon hour today. The first is assembling and defending the medical record in a way that preserves the integrity of the chart and assists with providing a very efficient defense. Second, we're going to discuss the importance of preserving and analyzing internal policies and procedures and how that impacts the standard of care that applies in the case. Third, we're going to talk about the importance of witness preparation for depositions and the need to identify the key individuals who are involved in the care at issue. Fourth, working with co-defendants and co-defense counsel. And fifth, determining whether to put on a damages case, which is often a very significant strategic decision to make. And so, John, gathering a medical record is often a very mundane and tedious task. Why does it matter what the chart looks like?
Erin, that's a really good question. The chart is probably your most important piece of evidence in a medical malpractice case. It's the contemporaneous entries by your staff, and that is probably the best evidence of what happened. Likewise, plaintiffs realize that, and plaintiffs are going to do everything they can to challenge the integrity of the chart. And if they are capable and successful in challenging the integrity of the chart, then it undermines the narrative that we have of the case. It undermines our key evidence, and the jury is left with the impression that they cannot rely on the chart, and once that happens, the ability to defend the care goes down significantly. So the key things, and how do they challenge the chart? Well, it's from issues as mundane as poor copying of the medical record, missing pages, data produced differently. If it's electronic data and we're printing it out on paper, it can be produced in a multitude of ways, and sometimes those differences are material, and plaintiffs will seize upon those. Another way is by having late production of materials, and oftentimes we produce the chart only to realize later on there are things that are missing from the chart. So the better approach is to have all of the records together and produced one time. And your assistance with us in pulling together the chart one time and producing it in one instance is the most important thing we can do. So, and lastly, to avoid a claim of spoliation, we want to have the record in one complete set and not produced piecemeal. With piecemeal production, you run the greater risk that the plaintiff lawyer will go to the court and argue that there is spoliation in the chart cannot be relied upon, and will seek to have an instruction to the jury contrary to the medical chart. And so this issue, while very mundane, Erin, is a very important issue for us in our lawsuits.
And speaking of the mundane and sort of responding to paper requests, the next issue we'd like to talk about is the initial request for medical records that comes from the plaintiff. So typically, this is received directly from the patient, the potential plaintiff, and is signed by that individual. And oftentimes that request for records does not adequately identify the time frame and the scope of the relevant records. And in instances, particularly in long-term care settings, or other instances where it's not clear the scope of the records that they're looking for, it's permissible to follow up with that individual to make sure that you are gathering what they're asking for. And gathering those chart materials is more than just calling down to the records department. There are a number of considerations that are critical to producing one complete record one time. And again, that is critical to preserving the integrity of the chart. And one of the sort of common pitfalls or issues is how to deal with incident reports. So first, incident reports should not be kept with the chart for a number of reasons. First, they are not technically part of the chart in the sense that the chart will set forth the care. and that these incident reports may contain information that is protected by the peer review privilege, which has two primary elements. First, that it's created with the purpose of triggering a peer review investigation, and second, is maintained in a confidential, separate manner after the fact. And so these incident reports should be kept, again, separately from the chart. And these materials in most states are not required to be provided to the plaintiff in response to the plaintiff's initial request for medical records prior to litigation. And also, metadata falls into that same category of materials that you are not required to provide to the plaintiff or the patient in response to their initial request for medical records. And metadata is, and when we're dealing with electronic records, is the information about who has accessed the information, when they have accessed the information, when the chart was printed. All that information can be important in a case, obviously, and is not something that you need to initially provide to the plaintiff. And finally, to be aware of often overlooked records from different departments, such as physical therapy or occupational therapy, and to make sure that when you are gathering those records, that you are looking across your organization to make sure that you are gathering everything the first time. And along those same lines, especially when you're dealing with a patient who has been in a long-term care setting, such as in a nursing home, often a provider will thin the chart. So we'll take out sections of the chart from 4 or 5 years ago, 2 or 3 years ago, and it's important to know that when you're dealing with those thin charts, that if there are entries or information that are archived elsewhere, that those must be gathered as well, depending on the scope of that individual's request. And this is the point at which it is important to potentially engage with outside counsel in figuring out those issues, so that the first time the chart is provided, it is complete and accurate.
And there's some special issues that we should also consider when we're dealing with paper records. We're sort of in this hybrid world now where some of the records are paper and some are electronic. And when we're dealing with paper records, we need to make sure that we have a full and complete copy of the record. Original records should not leave your facility unless they're under a court order, and we'll talk about that a little bit further along in our presentation. But when we are copying the records, extra care needs to be taken, for instance, on trifold pages, often used in OB cases. It'll be a very big record that folds out that the nurse is able to flow chart the care across a large 3-page document. Those are notoriously poorly copied, and pages are often missing from those, and that's something that extra care should be taken. Additionally, we have to preserve the chain of custody of our medical record, and we have to know who has accessed the medical record and when they have accessed that. So if you have a records department at your clinic or at your facility, it's important that every time the chart is checked out, that we have a record of who checked it out and when they checked it out. In fact, in Corpus Christi, one of my clients, if an incident occurred, she would then go immediately and make a copy of the chart and put that chart in her, quote, evidence drawer that she kept because she was not always sure what would happen with the chart later on, and she wanted to be able to defend her nurses and to make sure the chart was complete at the time that she was on notice of a claim in case something came up. And this may sound extreme, but changes in the chart do happen, and when the changes happen, it significantly undermines our ability to defend. I had an instance where a resident got a notice of claim letter, and she checked out the chart and wrote hold next to the DDAVP medication she ordered. Well, that late entry after the patient's passing was completely inappropriate, and the sad thing about it is that the care was defensible, but in her panic because she was named as a defendant, she made a change to the chart that resulted in the case and the care being indefensible. So it's important that we limit and we know who has access to our original medical chart. Likewise, with electronic records, we have specific issues in terms of how we gather the data. The screen view that most folks see at the hospital looks vastly different than how the record is printed. And so data that is actually very usable on the screen is very difficult unless some effort is taken by the folks gathering the chart to make sure that it is complete and accurate. And so the example I have is that while it looks very clear on the screen what the nurse was charting, when the chart was actually printed to be produced in litigation, every box that could have been checked and was not checked also printed along with the boxes and areas where data was in fact entered. So extra care and time has to be taken, because blowing that up and showing that to a jury makes it look like our nurses were not entering into the chart those key pieces of information that they should have, because there are a lot of blank spots. And so when we produce our electronic chart, we have to have an eye towards how that evidence is going to be used in litigation and how it will look when it's blown up on a chart. So, Erin, we talked about the records and making sure the records are complete and that we limit the access to those records and who has the ability to make changes to those records. What other types of evidence do you think it's important for somebody at a clinic or at a hospital to think about ensuring that they keep for a medical malpractice case?
Well, depending on the type of case, there are a number of different types of physical evidence or records that are maintained separately from the chart that should be preserved and gathered. In birth injury cases, for example, the fetal monitoring strip. So that's often the printout, the paper printout, the long piece of paper that was maintained. And that is often stored offsite or in a different place. And many states require providers to maintain these monitoring strips for a number of years. And so it's important if you're dealing with a case that may involve labor and delivery issues to make sure that you have an electronic or paper copy of that strip. With respect to medical device cases, if possible, to preserve the device packaging materials that were actually used in the procedure and any instructions or anything else that went along with the device, including any portions of it that were used to deploy the device, is very helpful to keep in preparing a defense of the care.
That's a good point. In addition, on a case where you can identify that that your lab is going to be of key importance, lab testing equipment, calibration reports, and internal documents that deal with the handling of specimens for the plaintiff are very important. Those type of records don't typically make it into the medical chart, but they will be important, especially when you're trying to build the timeline of between when a sample was drawn and when a report came out. And the internal documents will often be time stamped along the way, showing where the steps were in processing the sample. Additionally, in pharmacy cases, the compounding formulas are very important, and the mixing data sheets are very important. I had a case where heparin was given to newborns, and the compounding formulas were very important for us to help establish that the pharmacist, in fact, did her job correctly. So those extra sheets, and if you identify that as an issue in your case initially, protecting those documents are very important. Another issue that comes up, and you may receive questions yourself about the records and whether peer review or incident reports or things like that should make it into the medical record. And as Erin said earlier, no, they do not belong in the record. What is important is that the record accurately and thoroughly state what happened with the patient but the incident report or any peer review type document does not go in there. What goes into the chart, those are separate because those are the documents that trigger the investigation into the quality of care, and we have a right to look at the quality of care without fear of having to produce it in litigation. Now, there are other privileges that may apply too. There's hospital privileges in some states, nursing privileges, and also the attorney-client privilege if you have a lawyer involved early in the investigation. And all of those types of documents that don't deal directly with the care rendered to a patient should not be part of our chart. So for considerations for risk managers or folks at clinics, these are some of the things that I think are important to keep in mind. Is incident reports should not be in the chart. Your staff should be trained and understand that the incident report that they prepare, that they send that down to you, the risk manager, and not make a copy for the chart. Along the same lines, they should also not take part of their note and staple it to the incident report. I've had that happen a couple times where a nurse who is dissatisfied with something that happened actually took her notes from the chart and stapled it to the incident report and sent it down. And so now we end up having this big gap in the care and the record of the care because it's attached to an incident report. So training our folks in that, understanding that is very important.
And as we discussed earlier, again, the goal in assembling the medical record is to protect the integrity of the chart. And one way to do that and to set the key documents up in the case in a way that is very efficient is to make sure that care is taken in printing those documents in a usable format such that the record captures all of the information, but not in a way that makes it look as if there are gaps or that particular options in the care chart weren't chosen. For instance, when you're dealing with an electronic medical record where the nurse or the physician has an option to check a number of boxes, that when you provide that record, that you don't have just pages and pages of blank boxes that weren't checked, because that may, especially viewed by a jury, look like there's a lot of missing information from the chart, when in fact it's just that this particular individual only had a couple conditions or issues that were provided for in the chart. And then also, again, to restrict physical access to original charts, to make sure that all of those materials are there and that they are not changed. And again, to emphasize the fact that the defense of the case becomes exceedingly more difficult when the integrity of the medical records is lost, and that we want to minimize the need to continue to supplement the medical record, because sometimes and oftentimes a plaintiff's attorney will try to infer some nefarious reason why there are additional supplements to the record, when in fact it's just an issue in terms of records gathering, especially across geographies or across different individuals who are responsible for different aspects of it. And so John is going to give us a couple examples about the chain of custody issues.
Erin, chain of custody is extremely important for us in our medical malpractice cases. We need to be able to establish that the record did not leave our custody from any time after the care was rendered until trial. And so we do not give the original chart out. You should never give the original chart out even to your lawyer. A copy should be made, and the lawyer should verify that it's a complete copy. But even your own attorney should not be given a copy of the original, so that you are able to go in and say that this is a true and correct copy, that there were no any opportunities for people to alter the record or to change the record, and nobody had access to it other than the actual providers who are making contemporaneous entries. Surprisingly, this does not always happen. I had a case in New Jersey where counsel for a nursing home produced voluntarily the original nursing home chart, and the counsel for the physician went through the chart and pulled pieces of the chart out and attached it to a deposition. Now we don't have the complete chart in one place, and I said to him, I don't know how you're going to authenticate, if we go to trial, how you're going to authenticate this chart, because pieces are now everywhere, and they are now not under the control of an individual who will be able to come in and testify before the court. The only exception to this rule would be if there is in fact a court order, and every now and then plaintiff will seek a court order to have the original chart examined for handwriting purposes or other purposes. We generally contest those unless there is good evidence that there is a reason to do such an examination. We even contest the production of the original chart at time of trial unless they're able to establish good reason why the original has to be there instead of a copy of the chart. So unless there's a court order, the chart really does not need to leave the facility under any circumstance. And so sort of as a summary slide here, production, we want to make a complete and full production initially. We want to look for gaps in the medical record, find them before we produce them. We want to go and see if something got stapled to a incident report by accident. If there was a peer review event, sometimes records get pulled from the chart and end up in peer review. We want to look at all those things before a copy of the chart leaves the institution. And the last bullet point here is something that I've sort of run into more recently. Erin and I had a case in Arizona where the same type of repeat language, even with spellings and errors in it, appeared over and over again in the electronic record. And what appeared to have been happening is that some of the folks had figured out that they could cut and paste out of the electronic record into a Word document and then copy the material from the Word document into their new entry to save themselves having to rewrite the language. And so if you are noticing this issue in records and some sort of review process that you're doing, the right answer is that you have to disable that, because it does undermine the credibility of your chart to have the same language over and over again when other records may be indicating the patient's condition has deteriorated, yet your entries along those lines do not follow the same sort of analysis that was there. So that's very important. And also I've noticed that there has been a lot of auto-populating of diagnoses and diagnostic codes, and that those codes repeat themselves pretty routinely, and sometimes those codes are in error. And so if you have auto-repeating or auto-replicating of data in your electronic chart, it can create problems in your litigation. So Erin, once we have a complete copy of the chart and it's been copied and provided to defense counsel, tell us a little bit about what we do with the records once we receive them.
So once we as outside counsel receive the record, the first thing we're going to do is we're going to look through the physician's notes to determine if there are any missing entries, any categories of records that may have been omitted, gaps in the timeline of the case, in the continuity of care, and we're going to identify documents that may be protected by the peer review privilege, and to ensure that those materials are not inadvertently produced, because to do so would be to waive the privilege. Which exists in many states. And so, again, when you produce the medical record to outside counsel for review, it's important to have an exact copy of what you may have already produced to the plaintiff in response to their initial records request, to make sure that nothing is omitted and that we're consistent about that. And as part of that initial review, one of the key tasks early on in a case is to have counsel or a paralegal prepare a detailed timeline. And that timeline will identify the key dates of care, the key providers who were involved in that individual's care, and will help counsel understand the chronology of the case, sometimes down to the minute or second, depending on the type of case involved. And as part of that process, we will Bates label and number those documents and provide the client or the provider with a timeline, a copy of that timeline that lays out the key facts in one place. And that's for a variety of reasons, to first begin analyzing the merit of the legal issues or the merit in the case, but also to make sure that we have all of the necessary materials early on.
So Erin, let's turn to talk about policies and procedures. So what should we be doing about these documents from a litigation perspective?
So first of all, with respect to previous or old policies and procedures that may have been in effect at the time of the care at issue, to make sure that those are preserved. And later on, John's going to talk a little bit about how that impacts the standard of care, but it's very, very important to maintain copies of those procedures because likely the plaintiff's counsel is going to ask for them in their initial discovery requests. And in instances where there is no specific written policy on an issue, for instance, I have handled a case in Iowa where the issue in the case was the communication between the laboratory technician and the physician about a patient's contrast dye allergy. There's no specific policy that deals with that issue, but you can look to patient allergy concerns or just general nursing policies or things like that. And then in the absence of a specific policy, it's an issue of clinical judgment. And so it's just important to understand how important those policies and procedures are.
And the law in most states, and the reason why policies and procedures are typically we have to produce them, is because the law is that policies and procedures represent, quote, some evidence, close quote, of the legal standards of care that will be applied in the case. And so if you don't have the policy and procedure that was in effect at the time, then you end up having to defend most likely a more comprehensive policy. My experience is that policies get more complicated and more comprehensive as time passes through revisions. And so what you want to do is actually have the policy at the time of the care so that you are defending the policy that the nurses had available to them. Current policies oftentimes will impose new duties or additional duties that weren't being done at the time. And if you're producing that policy, the plaintiff lawyer will be contrasting what that is requiring to be done now versus what in fact happened at the time. And that usually sets it up to make it look like our nurses were not doing what they should have done. So keeping the policies that applied at the time and having those available in an archive is extremely important. So next, we wanted to turn to the issue of witness preparation. And witness preparation is very important, and you helping us make sure that we have access to your folks and have the ability to meet with them is probably the second most important thing. I think having the chart and being able to defend the integrity of the chart is paramount. But secondly, the most important thing is having the time to meet and prepare witnesses for their depositions and for trial. And the reality is that there are essentially two types of defense lawyers when it comes to witness preparation. There are lawyers that are really good at telling you about how bad your folks did in deposition, and then there are lawyers who actually sit down and spend time with your witnesses and helping them do the best job that they possibly can. And so we like to think that we are the type of lawyer that will maximize your employees' ability to do well. And so we have a number of meetings with the witnesses to get them comfortable with us, get them comfortable with the litigation process, to talk to them about the standard of care. And that's one of the biggest problems that we face as lawyers is the notion of standard of care in the medical world is very different than the standard of care that's going to apply in a deposition. And educating folks on what that difference is extremely important. So we like to meet with witnesses initially. We like to meet with them a number of times to prepare them for their deposition, and then meet with them again to get them ready for their trial testimony. So we begin this process by, as Erin said, having a chronology and examining the medical records. We have initial interviews with people that we think that are likely to have played an important role. And then we like to work on defining what each witness's role was in the plaintiff's care and making sure that we fully understand where they were involved in the care and what their role was in the care, because plaintiff lawyers like to overstate individuals' role in the care and see if they are able to get them to say something sort of on the periphery that is helpful to their case. We also like to meet with witnesses because we want to help try to identify who it is that the plaintiff lawyer might seize upon as their, quote, poster child. And so the example that comes to mind is I remember meeting with a L&D nurse and who probably had delivered, half the babies in Phoenix, but she, while very good at delivering babies and understanding moms and babies, didn't remember all the medicine that she learned in nursing school, and she confused diastolic and systolic blood pressure numbers. And in that initial meeting, it was clear that there was a lot of practical knowledge that she had, but there was a lot of medical a lot of things about medicine that were relevant in a deposition that she didn't remember. So how do we go about preparing people for that type of deposition so that they can do well? Well, we first try to limit the scope of their testimony to what it is they actually really were involved in plaintiff's care. Secondly, we go through medical terminology. We rediscuss the medicine that they probably learned but may not remember on a day-to-day basis. And then we also talk about medical decision-making. Many witnesses are very, very good at knowing what they need to do for their job, but the medical basis of why they do what they do, they don't always understand really well. And so we try to spend time with witnesses to prepare them so that they can explain the medical decision-making about why they did what they did. And the best example of that is I had a case where a baby had apnea as a newborn, and the nurse understood the importance of detecting whether apnea was there and knew that she needed to rouse the baby if there was apnea, but she did not fully understand the consequences in terms of lack of oxygen and the impact on the brain. And so we need to make sure that they understand that, so when causation type questions are raised in their depositions, they are fully prepared to explain that and not be a poster child for the plaintiff, showing that we didn't know how to care for a child. So in our second meeting, what we will often do is we'll anticipate deposition issues and questions and practice how we might want to answer those. We also talk about the legal standard of care not being the same as the medical standard of care, because the legal standard of care is what is the minimum accepted in the same or similar circumstances for caring for somebody, which is not what nurses or doctors understand when you say medical standard of care to them. They think that's the best current thinking on how to take care of somebody. So we have to educate folks about what is being asked in a deposition. We also talk to them a lot about the themes of the case and sort of what we think a key issue is going to be in the case, so that they can answer questions consistent with how we want to defend the care, even though we may not have spoken about a particular question. So for instance, in a case where we had an individual with ALS who developed a decubitus ulcer, the issue for us was dignity, and this individual wanting to be up in her wheelchair and wanting to be in the common area, and that being very important, and that was part of the theme of the case. And so when we met with witnesses, we talked about that as an important theme of the case, and so they could answer questions that we hadn't anticipated based on understanding of kind of how we viewed the best way to defend the care. And then we also talked to them about reasons why they might deviate from policies and procedures, how to avoid criticizing other care providers, and the role that medical literature plays in cases. Medical literature does not define the standard of care, and many folks, unless you prepare them for that, will not understand that completely.
So John, after you've had those first two meetings, what types of additional preparation do you do right before a provider is deposed?
Well, we like to have those meetings so that we go through the issues in great detail, and then the day of the deposition, we like to, again, re-emphasize the importance of the standard of care that's going to be asked about in the deposition, how to handle objections, remind them about the themes of the care, and how to avoid being critical of other care providers. So, Erin, in a deposition, what type of questions might plaintiff counsel ask care providers about in terms of their preparation?
Well, often one of the early questions that a plaintiff's attorney will ask a deponent who is a provider is what they reviewed in preparing for their deposition, because any materials that individual reviewed in preparing those materials are discoverable. And so we have to be strategic and a little bit careful in terms of what we provide that individual. And often we will provide a limited set of medical records that are relevant to that individual's role in the plaintiff's care, and not provide a set of all of the medical records to make sure that those issues are focused. And another key piece of this is making sure that the internal discussions that happen between various employees at your facility are not detailed in terms of the issues in the case and the ongoing litigation, because those discussions, those employee-employee discussions, can also be subject to discovery. They're not protected under the attorney-client privilege necessarily, because counsel wouldn't be present. And so often those internal discussions can characterize the care in a way that is inconsistent with the themes of the case or issues that we're hoping to develop in deposition. And so for that reason, our role as outside counsel is to prepare people for dealing with difficult questions that may come up, but without having the sort of internal sub-conversation that's going on.
So in terms of logistics, and this is something that you can help us on significantly, is when an employee is being deposed, it's important that they not have to work the shift before. I remember having a case in Houston where the witness said, you just let me sleep for about 15 minutes and I'll be ready for this deposition. And after working all night, and we said, no, we just can't do this. And so we canceled the deposition and rescheduled for a time. So it's important that our employees not be distracted by having just come off a shift or working the full night beforehand. Also, it's important that you remind witnesses that they really should not be talking to each other about the case. And it's also important that you remind them, in addition to us, the importance of being on time in attire. I had a case one time where this very nice lady came to the pre-deposition meetings always wearing a long sleeve shirt, and then the day of her deposition she thought she should wear a short sleeve shirt that showed these really impressive tattoos on her arms, and so we went looking for a sweater for her to wear. So it's important to remind folks of those issues. And here again, just some deposition pointers. These are the basic things that we say in almost every case. Let's turn to deposition pitfalls. We spend a fair amount of time talking to witnesses on what to do about friendly plaintiff lawyers, and actually friendly plaintiff lawyers are more concerning to me than the ones that are mean and grouchy. And so we remind our witnesses that the plaintiff lawyer is not your friend, and no matter what, they're trying to get something from you that is helpful for their case. And we want to talk to them also about policies and procedures, again, medical literature and regulations. So let's talk next about working with co-defendants, Erin. What about co-defendants? What role should counsel and our clients play in the relationship with co-defendants?
Well, a couple key pieces of this is making sure in your defense of the case that you have a fairly cooperative relationship with both co-defendants and co-counsel. And the reason for that is that often a plaintiff's attorney will like to see a lot of tension between the parties that comes out in litigation, because it helps the plaintiff lawyer essentially do their job for them, which is to sort of poke holes in the facts and in the law. And that's why it's really important to work together with co-defense counsel and co-defendants as much as possible. And part of that as well is when you have a situation where a co-defendant is continuing to practice at your facility, to make sure that that working relationship is maintained, and that there aren't things that cause initial or additional tension. And another aspect of that co-defendant relationship is evaluating sort of where the defendants are in terms of liability exposure, which is the next topic John's going to talk about.
That's correct. The jury is going to be responsible for apportioning fault between more than one defendant, if there's more than one defendant in the case. And that is a very important issue. And when defendants point fingers at each other, it drives up the value of the case, and it risks having more fault on you if you have your co-defendant angry at you and saying hostile things towards you. So it's most important that we work together and that we understand the pressures that may be on our co-defendants. For instance, if a co-defendant has probably more liability but is underinsured, it's very important that we work closely and strategically with our co-defendants to not allow plaintiff to isolate them, not allow plaintiff to scare them into thinking that they have to be critical of us in order to defend themselves. Additionally, we try to work very hard to strategically set up our causation defense in a way that allows everybody on the defense side to work together to resolve the case on causation without it having a negative impact on anybody else. And my experience is if you can have a joint defense on causation, then it makes it easier for folks to have a joint defense on standard of care. It's easier then for the doctor or the hospital's employees to not be critical of issues that come up with regard to standard of care. Another issue we wanted to talk to you about is evaluating whether to put on a damages case. And the key issues here are whether or not you have exposure beyond your insurance coverage. And so this is a part of the case that you, as a representative of the facility or the clinic, have to be involved in and have to help make an important decision on. And it's really, there are three parts to the relationship. There's the attorney that's involved in representing you, it's the clinic that you work at, and it's also the insurance company. And so you have to take into account what insurance is available and what information the insurer is telling you. You have to listen to the evaluation by counsel, and you have to make a decision as to whether a damage case is necessary. And you need to be active in this decision making, because many defense attorneys, typically do not put on a defense on damages. They will only put on a defense on liability. But if you're looking at excess exposure, you have to have a role in that and say, hey, wait a minute, we need to also think about how we're going to defend ourselves on damages. Sometimes you might need outside counsel to give you advice on whether the insurance company is giving you the right answer. For instance, we were hired not too long ago to look at whether an insurance company had properly stacked policies to say how much money was available to defend the care. And we concluded that they had not, and were able to write a letter, and were surprisingly able to get the insurance company to agree to our interpretation of how the policies should be stacked. So the traditional rule amongst many defense counsel across the country is that they do not put on a damages case because they think that it undermines their liability case. excess verdict, it would be the main reason why you would consider putting on a damages case. But my experience has also been that jurors are more sophisticated than that traditional rule takes into account. I have done probably 30 or 40 mock jury trials for various cases over the years, and we always ask the question, because we put on a damages case, did that make you believe that we weren't confident in what we were saying about the standard of care? And in almost every single mock jury experience I have had, the jurors were sophisticated enough to understand that the demand by the plaintiff was so significant that we had to put on a damages case. Additionally, in the past I've used some outstanding life care planners. One of them that comes to mind was Jack Sink, and Jack was able to answer questions for jurors that they don't typically get to have answered if you avoid putting on a damages case and follow the traditional rule. The jury often wants to know, for instance, in a cerebral palsy case, they will often want to know whether the child will have a normal IQ. Can they fall in love? Can they get married? Can they have a family? And if you put on a damage case, you answer those questions for the jury. And can they have a job? Another question that is often would be answered by putting on a damages case. And by giving them some reassurance that despite having cerebral palsy, that this individual can lead a near normal life, it gives them, I think, confidence in many instances to say it's okay to not find liability. And so contrary to the traditional rule, putting on a damage case does often make sense. So this is something that you, as a representative of the clinic or of the hospital, probably want to have some sort of input on. Now, what plaintiff will normally do is they'll have a life care planner, an economist, and they'll sort of state what the present value is of their damage case. And alternative to that, we would put on sort of a life care planner of our own, somebody like Jack Sink, and then an annuity broker who then provides an alternative to what the economist does. And the economists that plaintiffs hire manipulate the present value calculation by overstating inflation for medical care and understating the rate of return by investing in extremely low-yielding short-term treasuries. And while annuities are not as valuable now as they were 5-10 years ago when interest rates were higher, you still get a better deal through an annuity. And the additional advantage of putting on damage testimony with an annuity broker is that the annuity contract through the insurance company provides a lifetime stream of income. And if the economist is wrong and they overestimate, there's a big pile of money at the end. If they underestimate, then the plaintiff doesn't have enough money to cover their future care needs. That's solved by an annuity because it is a contract for the lifetime of the claimant. And so putting on that evidence is very helpful in allowing us to properly address the damage claim being made.
So in conclusion, we've covered five topics this afternoon. The importance of maintaining the integrity of the medical record and some tips for assembling those materials. Second, understanding the themes of the case and the importance of policies and procedures and maintaining copies of past policies and procedures that may have been in effect at the time of the care at issue. Third, differentiating between the legal standard of care and the medical standard of care and how that impacts preparation for deposition and interviewing care providers. Fourth, working with co-defendants and co-counsel to drive down the value of the case, to be very cooperative in terms of preparing for trial and certainly in discovery. And finally, damages issues, whether to put on a damages case, which is a major strategic choice that needs to be made early on in the case because those individuals that you would potentially put on would be an expert that would need to be disclosed. And so that's a key choice early on. And so, in conclusion, if you have any questions, we would encourage you to please feel free to reach out to us. We'd be happy to answer any questions you may have. And the next webinar is going to be December 10th, and the topic is the revised Medicare fee schedule and the OIG work plan.
All right. Well, Erin, thank you very much for all your help. Oh, we do have a question?
We have a question.
I just want you to briefly, we're still printing it, difference between legal and medical SOC.
Standard of care. As we were commenting, this is one of the most important topics on which we prepare witnesses. And so the legal standard of care is defined as what is the minimum accepted under the same or similar circumstances in caring for an individual. So it's sort of a threshold, a low threshold. It's the bar between saying the care was acceptable versus saying the care was not acceptable and there should be legal liability. Medical standard of care, when you talk to nurses or doctors, they think of that usually in terms of what is the best, most current thinking about how you should care for an individual. So we have to remember in a deposition that witnesses will be answering the former definition and not the definition that they are typically used to. And so standard of care in the legal sense takes into account sort of the facts and circumstances, and it is the dividing line between, yeah, that's good enough, that's acceptable care, versus no, we don't do it that way anymore. That's not how it's done at our hospital. And the standard of care is a legal notion that expert testimony will be used to flush out for the jury. Our policies and procedures are not the standard of care. We would not write a policy at our hospital or our clinic to be the minimum accepted. And so we work with our witnesses so they understand that if something was done a little bit differently than our policy says it should be done, that doesn't mean that we violated the standard of care. Standard of care is also not in textbooks or in medical literature, because most people don't write an article about the minimum accepted to care for somebody. They are writing about the best practices or the most current thinking on how to do that. So when we spend time with our witnesses, we try to get them to understand that the things that plaintiff lawyer wants to point to, literature, state regulations, the policy and procedure documents that we produced, that those don't define what they were legally required to do in a particular situation. Any other questions? Well, thank you all very much for your time and consideration of our presentation. And like Erin said, the next one will be on December 10th. Thank you.
All right, thanks very much.